practice. Patrick is the head of Allen Overy's arbitration practice, our host today. He has decades of experience representing Fortune 500 companies and sovereign states in complex commercial, contract, and investment disputes. He is widely recognized as one of the foremost experts in the world on investment protection and dispute avoidance. And for nearly 10 years, he served in the US State Department working on economic diplomacy. And he departed in 2017 as the chief of the investment arbitration there. I would like to really thank Allen Overy for its support, not only this year, but since the beginning of Washington Arbitration Week. This is an area that is incredibly important. I mean, the panel, to the extent that today some of the ECT investment arbitration awards have gone to different jurisdictions in Australia, in the UK, and now before US courts. And as we see that the ECT might be not necessarily surviving, the question becomes what will happen next? What could happen with those awards that have been rendered? And those are incredibly complex legal issues, but we have an incredible panel, an incredible moderator to address them. Patrick, thank you.
Well, thank you. Thank you. Apologies for the back and forth on tech. It's actually just such a privilege to be once again supporting Washington Arbitration Week. It's in my view the highlight of the calendar, in part because it's home, and also in large part because every panel is so substantive. And as far as I understand it, it's one of the few full week-long conferences where it's free to attend. So it's a really amazing thing that you and Ian and others have managed to put together. So thank you very much. It also is a little bit strange and humbling to talk about the ECT in Washington, D.C. Why have a panel on the ECT while in Washington? Well, you're going to hear why, but it's also fun because we get to poke fun at the Europeans a little bit and what they continue to do to a field that many of us respect. So without further ado, what I thought I would do is just introduce the panel, and then we're going to have a relatively free-ranging discussion on the ECT, what it is, how we got to where we are, what's next, and maybe some crystal ball gazing. But it's the end of a day. You've all been watching many panels, so questions throughout, we welcome them. We want this to be participatory, so please let us know if you can't hear us, or if you need a burning question or even a simmering question answered, and you think you can contribute to the conversation, just throw your hand up and I'll be happy to call on you. Okay, so to my immediate left is Alexander Vermunt. He is a partner at Deckert. He has a wealth of experience representing investors, states. He is an ECT expert. I tend to keep these intros relatively unique, relatively slim, so as not to go through their incredible CVs. Otherwise, we'd be here all day. But suffice to say, Alex is an expert, a dear friend, and has been practicing in this field, and particularly in this area for many, many years. Nikos online. He's the man who has been so disgusted by Europe that he put himself in space. Professor Dr. Nikos Lubrano. He, among many things, is an arbitrator, a mediator, a consultant. I think you have like 6 hats that you wear. I know you're a fan of double hatting, so there's 6 hats that you wear. And you are also primarily the Secretary General of the European Federation on Investment Law and Arbitration, which is an organization that I think he founded and has been very vocal in this area for many, many years. To great effect, we'll learn, Nikos. So we're looking forward to hearing from you. To my immediate right is Eureka Over. Did I say the last name right?
Almost. Overdarn.
Overdarn. She is senior counsel at Sovereign Arbitration Advisors, which, if you don't know them, they are an incredible group of lawyers and intellectuals here in DC who work primarily for states in this space, exclusively for states, I believe. And there's a very interesting perspective that she will bring. She's obviously worked on many ICSID cases and UNCITRAL cases and all the things that you would expect in order to be credible. So here she is, an expert, but giving us a European perspective, perhaps. And then to my immediate, or to my far right, maybe not politically, is Chris Feil. Chris is the current co-CEO of the Mintz Group. And that's a role that he's had starting this month, right?
That's right.
And he is a specialist in complex litigation, public policy disputes, and co-heads the firm's international asset tracing unit. So one of the questions that we're going to answer today, or at least talk about, is, okay, we have all of these awards. Now what? How do we get paid? What happens to them now that the EU is taking its putting its view on removing the ECT as a possible dispute mechanism? So without further ado, why don't we kick off? Eureka, why don't you start and tell us kind of why we are having a panel here on the ECT and the future of the ECT, and maybe start by, what is the ECT? What was it meant to do? And then how did we arrive to where we are? And then maybe, Nikos, you could weigh in on your own view from 85,000 feet and let us know what you think. Eureka.
Thank you, Patrick. Let me see if I'm still here. If not, we should do it without. Can everyone hear me? Well, thank you all. Thank you here in person and online for joining us. Also for my fellow esteemed panelists and the organization for inviting me. And indeed, to give some sort of a European perspective to something that might be puzzling for a US audience or an audience that is not skilled in European law. But to start maybe with the main question, why are we here? We are here today to discuss the Energy Charter Treaty, a treaty which has 54 members today, including 27 EU member states and the EU itself as an organization. And it was founded in 1994. The treaty text as such has not seen any change until recently, and Nikos will follow up shortly on the effort to modernize the treaty that has at least not seen any subjective change since 1994, apart from an additional annex, an additional agreement on transit that was added in 1998. This treaty has been a mixed investment treaty, a mixed agreement from the start. What does that mean? It means that the EU and its member states are both individual and as a whole member to the ECT. That has turned out to be quite problematic in the end, since particularly after the joining of Eastern and Central Eastern European countries that joined in the 2000s, and actually ever since, all of the treaties that were supposed to be outside of the EU became suddenly an intra-EU issue. So what is the issue actually with the intra-EU application of the ECT? For that, actually, I will take you back to the very foundation of the European Union, to the Treaty of Rome, 1957, that actually foresaw in an ever-closing union and also laid a foundation for the internal market. The internal market comprises of the freedom of goods, services, capital, and persons, people. It is a bit of a strange nature, because what is the EU? The EU is an organization, international organization, an international organization, but also it is an organization that consists of 27 individual sovereign member states that are sovereign, but not entirely. So the EU is founded as a market that actually sees itself as one single territory with one single market. And EU law is within that whole framework to be treated as the EU constitution. EU treaties are primary law, EU treaties have primacy over domestic law. It has direct effect, and in case of incompatibilities, that domestic law is not to be applied. And similarly, incompatibilities with international legal obligations are also deemed to be incompatible, and member states have a duty of loyal cooperation to remove that incompatibility. The Court of Justice of the EU is really kind of the Supreme Court of the European Union, and also sees itself as endowed with the task to ensure the uniform application and interpretation of EU law. That includes the binding and the application and interpretation of international treaties within the EU, to which EU members are a member. And I think that is also one of the problematic issues that my colleagues also will discuss later today. But what happened in Achmea was really one of the first, or is the first, decision of the Court of Justice in which the Court of Justice clearly says that the application of investment treaties within the EU are incompatible with EU law. For the reasons, actually there's only one reason, because it threatens or is incompatible with the autonomy of EU law. Autonomy of EU law is basically another word for the EU constitutional framework. What does it do? I mean, the Achmea actually the decision, the Court of Justice derives at that decision basically following a three-step analysis. First, it assesses whether a tribunal needs to interpret or apply EU law, potentially. I mean, the question and the underlying arbitration agreement in this case was the Slovak and Netherlands BRT. Secondly, is the tribunal a court of the member states, or can it actually have access to those courts? And thirdly, is there any way of judicial overview of the Court of Justice? So following these three steps, the Court of Justice derived at the conclusion that investment treaty arbitration within the EU, well, first in Achmea as included in BRTs, but later in Comstroy and also in PO Holdings, the court extended that reasoning to the Energy Charter Treaty and ad hoc arbitration agreements. And later in the Mikula case, they did the same to any exit arbitration. But the fundamental dogma that the European Court of Justice basically has applied is that any international obligation that may interpret or apply EU law within an EU framework is incompatible with EU. And I think maybe before I turn over to Nikos, I'd like to stress that the issue has been quite complicated in context of the Energy Charter Treaty because it's a mixed agreement. To the Energy Charter Treaty, it's not only EU member states that are member, but also other parties. And if you follow the dogma of the European Court of Justice, I think it makes sense that within the EU is considered as one big bubble, one big territory, just like the United States is for the US Supreme Court. Also here in the US, you have a system of judicial overview where the US Supreme Court annuls actions from states amongst each other, and if it's deemed to be incompatible, it cannot be appealed. But that is within the realm of the United States jurisdiction. Similarly, the EU applies this to the EU territory.
Of course, an international arbitration applying US law outside of the US is fully compatible with US law, and the Supreme Court would take no issue in enforcing that arbitration award. But Nikos, what do you think? ECT, give us your view. What happened? Thank you very much, Eureka.
Yes, thank you so much for this super concise introduction, Eureka, and thank you, of course, to the organizers for allowing me to speak, even though I'm not in the room. But then I thought, I'm also quite green, and that is, of course, something that the EU wants, given the Paris Agreement. I come to that in a minute. So in that sense, you could say I'm a good example of how arbitration conferences should be run. But I think to pick up where Eureka stopped, at a certain moment, sometime in 2018, the EU and the member states, and actually all ECT contracting parties, concluded that actually the ECT needs to be modernized, right? And there are a couple of drivers that were at play. First, following the Achmea judgment, which, as Eureka said, was related to an intra-EU BIT, dispute, we had the infamous Comstroy judgment, which is not actually an intra-EU BAT case or intra-EU ECT case, but it doesn't matter. Effectively, the CGU said that intra-EU ECT ISDS dispute are incompatible with EU law. So it extended the ACMEA case law. So that was one driver for the EU to somehow include explicitly the so-called disconnection clause, stating that intra-EU ECT disputes are simply not possible anymore. That was one important reason. Another important reason is, as you all recall, in 2015, we had the Paris Agreement. And as we all know, all the member states are lagging behind of meeting the Paris Agreement targets. And somehow also, I would say, assisted by the alarmist reports and pressure by NGOs, the ECT was somehow framed as supporting the dirty fossil fuels and has become an obstacle to the greening of the ECT and of achieving the Paris Agreement targets. So there was clearly another driver to, as the EU likes to say, to align the ECT with the Paris Agreement or to incorporate the Paris Agreement obligations into the ECT. So that was number two. Number three, very important, and you all know that I did a lot of work of it into it, is the spike in ECT cases against member states, right? We have the spike against Spain with the renewable energy cases of no less than 50 cases at least, running up into 1.2 billion US dollars of unpaid awards so far. But also the case against Germany, the Vattenfall case, that really spiked a huge public debate, as well as also the case against the Netherlands, where also Eureka has been working on. So that was not the intention back in the time, because we should recall that the ECT was actually developed to stabilize the energy supply from Russia, from Soviet Union that was crumbling after communism fell. That was the main reason. So there was no way of thinking that the ECT could ever be used against Spain or Germany or the Netherlands, some other countries. So these are effectively the drivers that sparked the ECT modernization process. And in an amazingly quick negotiations of 3 years under COVID, we had in June 22, we had an agreement in principle, signed or agreed by all ECT contracting parties, including all EU member states and the EU and everybody else. So we had an agreement, we thought, in principle, where Paris Agreement was included, where there was a explicit disconnection clause, so no intra-EU ECT disputes being allowed. There was a cut down of the fossil fuel protection from 20 years to 10 years, and a lot of other goodies, everything that the EU wanted. So we thought we could sign this up, but for some reason, and that is still for me a mystery, right after the summer in September 22, the meltdown started with every week, effectively every month, a member state announcing that it would withdraw from the ECT because it was not green enough, which is quite interesting. And this has effectively culminated in the announcement of the EU to initiate a common withdrawal of the EU and all EU member states. So effectively, we are now, after 3 years, having 2 treaties in the air, if you like. So we have the old ECT, still valid and applicable. And actually, as you know, there is the clash case against the EU, Denmark, and Germany, just initiated last month, if I'm not wrong. So cases are still initiated under the old ECT, while at the same time, well, Italy already withdrew a couple of years ago, but we have now formal withdrawals from France, Poland, Germany, and Luxembourg, funnily enough, right? So that is on the one hand, and the 20-year sunset clause would apply. But on the other hand, we still have the modernized ECT text on the table.
Yeah.
So that raises, and that I think leads maybe to the other speakers, that raises very complicated questions as to what happens with old disputes, what happens with pending disputes, what happens with awards that have been issued and are now being enforced in various jurisdictions. We are really in a very, very difficult situation. Just to conclude, so effectively, and I think that is very important to understand for the audience in the US, this is really a regime clash between on the one hand EU law and the supremacy of EU law that the CGU is imposing, even with extraterritorial effect, and on the other hand, basic public international law and treaty law that we have, which, I'm sorry to say, still is binding on the EU and the member states until, they are properly withdrawing from them. So this regime clash, I think, is the core of the problem. Thank you.
Thank you. No, that's very helpful. I'm going to bring Eureka back in, and then we're going to move to Alex. Before, I'm going to make one comment and then pose a question, but then Eureka, feel free to respond to anything that Nikos just said. The comment is, I think it's interesting, and I welcome any panelists to share their views, that the majority of ECT related disputes are disputes that were brought against states rolling back renewable investments, right? Or trying to regulate renewable investments in a way that was not consistent with what the renewable company thought it was signing up for. So it's interesting from a green perspective whether the ECT is green enhancing or not. Full disclosure, my firm does represent Spain, does represent many of the investors against Spain. That's my comment. My question is, what is the purpose of the ECT at this point? We heard from Nikos, and Nikos, I welcome your view on this too, because what I heard from you was a kind of apocalyptic view of regime clash, which I totally understand, but I haven't heard a new articulation of what you think the ECT provides as a benefit, other than basic ISDS protections, and we know how that goes. But from a sovereign perspective, from the kind of position of the EU, not that you speak for the EU, Eureka, but what does the ECT provide for what is its purpose at this point?
Well, thank you for the questions, and also Nikos for the elaborate introduction and follow up on the intra-EU saga and bringing it to more like international perspective. To start with your question, what is the purpose of the ECT at this point? Indeed, I do not pretend that I can speak on behalf of the EU or any member state, but coming from an EU perspective and knowing that 27 member states, including and the EU, which is half of the members of the Energy Charter Treaty, are in the process of withdrawal, or at least considering withdrawal. I think this is a question actually that should be answered also by the Energy Charter Treaty Secretariat and the other members. It was designed and it was written in an era in the 1990s when there was a lot of energy insecurity, and to provide the security and stability and energy cooperation across countries, border countries that are all connected, with a view actually to provide that security. And I think in terms of renewables, and every country will, particularly if they kind of have to adhere to the Paris Agreement, go through some sort of energy transition and will need to attract new investments. And again, also, you cannot do this alone as a country. If you look to hydrogen energy supplies or any other big new renewable projects, actually that requires cross-border cooperation. So I would see that there is still a need to provide some sort of security and stability. But the question is whether this energy charter treaty is still fit for that purpose, or whether we should think of something else.
Nikos, one minute on what the ECT's purpose is. You said it was ready to sign. If you were explaining to your minister, what would you say the purpose of it was?
Well, I think the purpose is still the same: promotion and protection of investments. And I would just expand with a single word, namely what Rico said: renewable investments or sustainable investments. That is still the purpose. And even though I don't agree with a very narrow FET definition and all the other modernization elements which reduce the element of protection, still investors need some sort of legal stability and access to international independent arbitration, because we know, unfortunately, that the rule of law in many member states is backsliding. So that is another point we should not forget. It is about access to independent arbitration. So the original aims are still valid. And I think really the modernized ECT text would have made the ECT fit for purpose for the net zero 2050 Paris targets. So I think that would be my explanation.
So to summarize, the ECT, in your view, Nikos, is fit for purpose if you believe, and I know you do believe, that the protection of investment promotes investment, right? You have to believe in that catechism in order to think that the ECT is a document, that a treaty that should be signed, right? And if you don't believe that protecting investment spurs investment, if you don't believe that, then you're an empiricist. You look at kind of other people's work and says it doesn't drive investment, then you don't think that the ECT really has a purpose. Yeah?
That's basically what the discussion is about. Yes.
I think you made news there. Alex, bring us in on why are we in the US? Why here?
I will get to that, but before I do, I want to answer your last question, because I think it is more of a subjective test. I know many companies who would not invest but for the existence of treaty protections, right? These energy investments typically involve hundreds of millions of dollars. It takes a long time to get a return. And whether you're investing in Poland or Hungary or France, you want to have the investment protections. So if companies think their investments are going to be protected, they are more likely than not to make the investment. Okay, so the United States, and let me take a step back. I don't know if everyone is as immersed in the ECT and in ACMEA and COMSTROI as others. So I want to make clear what ACMEA and COMSTROI hold. And I will say I also am representing investors in ECT cases against respondents, including in enforcement cases in the US. So here's the background, right? Under these investment treaties, the states make a standing offer to investors to bring arbitration if the investor thinks one of the treaty obligations has been breached. And the investor accepts the offer when it brings an arbitration. So we have all these offers and acceptances, and EU investors bring the arbitrations. The states defend them, hundreds of millions, if not more, in legal fees, tribunals, lawyers spending years carefully deliberating these cases. We get awards, and lo and behold, the Court of Justice of the European Union, the CJEU, says, oh, wait a minute. We have just figured out that the offer that EU member states extended to investors is void, because EU states even though they probably didn't know it at the time, they had no capacity to agree to these arbitrations. So, I mean, the issue of capacity, at least in the United States, is, you can't enter into an arbitration agreement with a child or with someone who's mentally defective. But if you're an EU state and you entered into an investment agreement, an arbitration agreement with an investor, you lack the capacity to actually do that, right? I mean, I'm an advocate, right? But I try to get into the position of my adversaries. I've read these cases in English. I've read them in French. I don't understand them. Frankly, I think they're outrageous. So then, once you have an award, and obviously you will not be able to enforce these within the European Union, so you will go to the courts of the United States or Australia or Canada, anywhere outside of the European Union, and these countries are obligated under their own treaties to enforce these awards, right? The United States, under the ICSID Convention, is required to enforce ICSID awards. It's required under the New York Convention to enforce New York Convention awards. And the European Union has now taken the position that no, US courts, I know you have this statutory obligation, I know you have this treaty obligation, but that's all trumped by EU law. EU law requires you to abandon your treaty obligations, to ignore your statutes. You just can't enforce these awards. So it's basically, we have domestic law, international law, divine law, and then EU law over all of it. All right, so a number of investors have tried to, including my client, our client, has tried to enforce the awards in the United States, in England, and in Australia. And I guess the good news from my perspective is that 4 of the 5 courts to consider the issue have rejected the EU argument. So in Australia, the High Court, which actually is the Supreme Court, unlike England, where the High Court is the court of first instance for these cases, the High Court of Australia in April of this year, in Spain v. Infrastructure Service, which involved an ICSID award, rejected the argument. It's a very straightforward analysis. It said our law and our treaty obligations require us to enforce these awards, whereas here, the state has clearly waived its sovereign immunity by entering the ICSID Convention, and so we're going to enforce. In England, another case by Infrastructure against Spain, rendered in May, also an ICSID case, and there the High Court went into a very thorough examination of ACMEA and Comstroy and the ECT and ICSID, and it concluded that it could not breach its treaty obligations and its law that incorporated those obligations due to EU law. EU law is not superior to English law in this context, or to international law either. Okay, in the US, of course, it's more complicated. The judges in the District of Columbia have gone in opposite directions, at least in the 2 cases or 3 cases that exist. So this past March, Judge Tanya Chutkan rejected the EU argument in 2 cases, 9REN and Nextera. And if that name is familiar, that's because she's the judge trying the Trump election case in DC. Very good judge. And she also thought that the analysis was pretty straightforward, right? There is an arbitration agreement, no dispute about that. Whether it's valid is another issue. And therefore, because an arbitration agreement exists, the arbitration exception to foreign sovereign immunity exists. The issue of validity under the ICSID Convention is delegated to the arbitrators, and therefore the US court cannot revisit it. So she found that there was clearly at least jurisdiction for the court to consider the enforcement case. In April, a different judge, Richard Leon, reached the opposite conclusion in Blasket v. Spain, which involves an inter-trial award that's not relevant to the analysis, but it's interesting. And Judge Leon, in a fairly cursory opinion, just accepted Spain's argument that under EU law, there was no valid arbitration agreement because of ACMEA and Comstroy, and therefore the arbitration exception doesn't apply. Now, the Energy Charter Treaty says that it's governed by international law, but Judge Leon didn't see the difference between international law and EU law. It's all non-American, so it must be the same. So these cases are now on consolidated appeal before the DC Circuit. Our appellate team, which consists of all former Supreme Court clerks, think that Judge Chutkan's position will probably be upheld, and that the decision will probably come down in the summer. So we'll see. But there was a time when the Europeans made fun of US courts for not understanding arbitration, for being parochial. And it seems to me that's entirely turned around. And it is very interesting that this argument of the European Union arose once Western states started to get hit with arbitration cases. Right, it was fine when Poland and Latvia and all those were, but France, Germany, we can't have that.
Well, thanks. So again, another disclosure, I'm counsel for the Chutkan cases, the successful ones, so I won't comment on the substance of that, but I will ask a question by way of passing to Chris, but to Eureka quickly. Is there a view that intra-EU investment protection is unnecessary? In other words, the EU law is sufficient to protect investment vis-a-vis EU states. So Nikos's prayer that if you protect investment, you will get investment doesn't apply to France, Romania.
I think actually that is fundamentally the core of this question, and maybe also it relates back to the story and hopefully my advocacy I did earlier, and going back to the Treaty of Rome. What is the EU? The EU is a hybrid organization. On the one hand, it imposes domestic law, supreme domestic law for the member states, and on the other hand, it is international law and the source of international law. And I think that is exactly also kind of what we are all trying to understand and to grasp, and also what our judges around the world are trying to hopefully interpret and apply in a way. And I have huge respect for the courts all around the world, so I don't want to also interfere in or influence one of those decisions. But I think the question is, and depends really on the lens that you are wearing, and from an EU perspective and EU law perspective, these are matters of purely internal domestic law about the law that applies between Netherlands, Germany, member states in between each other. It's a whole different ballgame if we're talking about the application of the Energy Charter Treaty vis-a-vis third countries outside of the EU. But within the EU law prevails, and that is something that is, from an EU law perspective, very clear. And the question is then, how does it translate to international law and to the cases that have already been pending and ongoing? And I think that is one of the questions also that this panel tries to grab.
And it might be why the EU itself signed the Energy Charter Treaty. But Chris, tell us in your view, what we do with the billions and billions of dollars in awards that now exist. What's just to kind of round it up, to kind of really present you the problem. Now what?
I think you've raised a lot of the exact questions on the policy questions here, but as somebody who makes my money essentially monetizing awards, do we need the mic?
It's right behind your computer.
Oh, there we go.
Yeah.
Lovely. For somebody who makes their living monetizing awards, it really presents a challenge when you deal with a system where that has, all the strengths of a unified market and otherwise, create an internal economy that is untouchable when it comes to enforcement. And so, as an investigator, we make our living identifying where debtors' assets or revenue streams hit jurisdictions where that are favorable for enforcement. And so a very glib response is, same dance steps, different song. Clients, you realize you have to narrow your aperture. You're not focusing on, the Netherlands anymore. You're focusing on the US, you're focusing on Australia. But how many, there've been, even just in the last year, the number of cases where I'm looking for small Eastern European countries, toe prints, not even necessarily hard assets, but toe prints in the US, it changes the game a bit. And, just as an example, and anyone here who's done enforcement knows, for years, the Netherlands was really the jurisdiction of choice to go to when you were dealing with enforcement issues. Both because on one end you had the ease of conservatory arrest, even before domesticating the judgment, but also because of the role that the Netherlands played within the European community. You had, tax benefits that made it so almost every joint venture you could think of is going to be domiciled there. You had one of Europe's largest port with Rotterdam, and you had the financial center for trying to chase after revenue streams or third-party debt, through banks based in Amsterdam. And so now what happens is the standard request is what can you find for us in the US, the UK, Australia, maybe some other jurisdictions based on the actual substance of the case. But what it may be doing is really reducing enforcement from strategy to tactic. And that's fine. I often talk to clients about the strategy is monetizing the awards, but how are we going to get there? And so, but by pure reduction to tactic, you're getting to this point where you have a single play, which is about real disruption. You're not going to be able to monetize an award necessarily by some procurement channel between the US and some European nation. Some order of transformers or rolling stock is not going to satisfy an award. Maybe it'll embarrass them. Maybe it'll disrupt something that's important internally to the politics of the country. But at the end of the day, it radically shifts the game and certainly changes the whole tactical maneuvering when you engage in this kind of in the enforcement strategy here.
Yeah, it reminds me of that meme that you sometimes see from Pirates of the Caribbean with Johnny Depp, where they're on the scaffold and he looks to his left and he says, "First time," as they're all both about to be hung, right? Because you're in a point now where folks who have practiced primarily in the ICSID or under the ICSID or really under international arbitration generally didn't have to face some of these questions when enforcing against the state. They would have to find assets, sure. State assets, get over sovereign immunity, et cetera, right. But not some of the questions that you're now facing for these awards. It's kind of like, well, welcome to the party. You're enforcing a judgment. So now, where does that leave us, I guess, is the question. Happy to take questions from the audience, but I also have some questions more for the panelists on where we go from here and what to expect. But first, let me pause to see if there are any questions from folks. Jose Antonio.
Just, a question, especially for Patrick and for Alex, and then this is a little bit more of a speculation than real law. What do you think is the effect on U.S. courts of having at the other side almighty EU arguing that that this cannot be done, and the way I see the EU argument, yes, we will understand, perhaps here that this is at best domestic regional law. But that is not necessarily the way they frame it before U.S. courts, because there's at least an implicit argument that for some reason European law is a treaty in itself, and somehow it is supra-international law. So what is your take what is your take with regard to the potential view of U.S. courts? I am very clear that if this was perhaps the Court of Justice of the Andean community, or if this were the Court of Justice of the African states, the view would be this is parochial.
Yeah. So when you have, I'll go first. I mean, although I'm not meant to be weighing into substance here, but when you have jurisdiction in a U.S. court and they're applying U.S. law, they apply U.S. law. There is a supervening U.S. law requirement to enforce these awards. So whether the EU is on the other side or there's an EU issue, there's a statute and there's a treaty and there's jurisdiction over these claimants, and you're in U.S. courts and they're applying U.S. law. I don't know what the almighty EU kind of shadow on that would really cow a U.S. court. They're applying U.S. law. Now, Judge Leon applied U.S. law in a different way than every other court that's looked at it, but they're applying the law that they have to, and in the United States, they're applying U.S. law because there's a U.S. law obligation.
Making predictions on how a court is going to rule is always tricky, right? But I mean, the English High Court and the Australian High Court didn't struggle all that much with it. The English High Court wrote a very thorough opinion, but at the end of the day, it was pretty obvious that the court had to follow English law. It had to comply with England's treaty obligations, and I think the DC Circuit will do the same.
Other questions from the collected crowd? So then I guess my next question would, please, Mr. Weiler, Professor Weiler, Professor Dr. Professor Dr. Weiler.
Any chance that the State Department might want to be involved in the appellate proceeding?
As a matter of course, at the State Department, generally they don't intervene at the district level, as we know. The appellate level is a different question, and of course, at the Supreme Court, there's a whole nother question. So,
The appellate level.
Sometimes the court will ask
Sometimes
the State's Department to weigh in. There hasn't been such a request so far, but on the other hand, oral argument hasn't been scheduled, and my sense is the court's really backlogged. So it's possible a request like that will come. Yes. Now, what's the State Department going to say? That's probably a better question for Patrick.
I'm not taking that one up. I think this is being recorded. I am not representing the State Department now. Any other questions from the audience? Another question.
Sorry. I actually have two, but one is, in your experience, how much weight would the decisions, if any, would the decisions of the High Court of Australia and the court in England might play? I know that it is not applicable directly, but these are both reputable common law system courts. Would that play any role in the system? And then the other question is, what, just from a faraway perspective, given what is going on in the world in terms of two wars, etc., how do you see the stance of the European Union with respect to the international rule of law?
That's one for you, Eureka.
I'll do the first question, which is that the fact, in and of itself, the fact that these cases come from the Australian and English courts, I don't think that will weigh heavily with the judges. And the Australian decision is really kind of cursory. I think the English High Court had a really thorough, well thought out decision, and that I think it may have persuasive effect with the court, but at the end of the day, the judges are going to do their own analysis, and they're very confident in their ability to do that analysis. So it will be an analysis that's based primarily on US law.
Yeah, and I would love to answer the question. I think, Nikos, maybe you have a better informed opinion on the question of the rule of law and the EU at this point.
Yes, I think it is one of those issues that is kind of like overarching our panel, and I think it's a very serious issue in the sense, in my view, that the way the EU and the member states have negotiated and now exited the ECT is, if you like, really putting the reputation of the EU as a negotiating partner at risk. And I think that is really serious because, the EU and the member states like to lecture other countries how to behave in terms of rule of law. And I think it's becoming very difficult for the EU to lecture other countries to respect the international obligations when they themselves fail to do so. And I think this is even worse in the case and in the area of climate change, where the EU is promoting itself and advertising itself as the front runner. And we will see that now with the COP28 meeting that is coming up, that, the EU wants to promote renewable energy and the transition, the energy transition. And I think what happened now is really a very bad example. So I'm very much concerned about that. And because, this can spill over in other areas of international, like human rights treaties, like other treaties where other states will say, look, you cannot lecture us anymore because look at yourself and how you behave, So I think it's really terrible what's happening in this respect. And also, maybe to add, or to come back to the previous question of Patrick, at the end of the day, yes, the world is not going to go down if we have no ISDS and no ECT. Sure. But the problem, I think, is simply shifting the costs to the end consumer. What you will have is you get a risk premium that energy producers, both fossil and renewables, will add to cover the risks, if you like, as an insurance, because we don't have neither the bids anymore and we don't have the ECT anymore. So there is also a social economic aspect for large parts in the societies. And we know now, as we speak in the Netherlands, we just had elections, that the climate efforts that are imposed on ordinary people is one of the elements that has driven many voters, unfortunately, to vote for right-wing parties. So there is this element as well that we have to take into account. Where are you going to push the costs for the end consumer for the energy transition? So I think this is something that we really should keep in mind when we take a bit more of a macro view.
Eureka.
Yes, it's hard to take the floor after such an elaborate response, but let me try to maybe end on an optimistic note, because there are two things actually I think that are for at least the EU on the way forward, maybe pressing issues. On the one hand, how do you deal with an ECT that will still apply for 20 years, potentially in an intra-EU setting? And that is something that should be solved in a way. And on the other hand, also, how do you coordinate a coordinated withdrawal from the ECT to avoid any of the potential fallout? And I'd like to stress, and maybe that was the optimistic remark that I wanted to make, that even though Achmea, Comstroy, Feil Holdings, they have been overshadowing a lot of the intra-EU arbitration cases, including, and they've also jeopardized the enforcement of these proceedings in foreign courts and courts around the world. I do think actually in opinion 117, that is the opinion of the European Court of Justice on CETA and the conclusion of CETA, it is very clear, and that is also something that kind of the court has repeated over time, that in the relation with third countries, EU member states and the EU can still sign treaties. They can conclude treaties. They can set up international courts if they wish so, or even adhere to and be bound by other courts, as long as it doesn't impose and violate the EU autonomy. And that is something that is an obligation for EU member states. And I think that functions in a similar way as here in the US. It kind of had the international law obligations that the EU and the member states sign up to are filtered through the filter of EU law. And basically, and I try to contain this discussion to just simply the intra-EU cases that are pending, and the rest of the ECT is probably still business as usual.
But of course, the EU hasn't allowed the CETA investment chapter to take force yet, right?
Not yet, no.
Questions from the audience, go ahead.
Yeah, well, I didn't want to stand in between all of us and drinks, but thought might as well ask a question on the ECT's modernization process, which was covered in nutshell, but not in detail. And I just want to know if Europe is better off or at a better place with the modernization taking place and the disgruntled member states now leaving the ECT without any of such protections, though they do have the sunset clause, which does protect investors. So is ECT member states better off, and the European Union as such, if they stay on with the modernized text, where there was at some point there was a negotiation on whether there could be waive off of the sunset clauses. The reason why I ask this is because it's not just Europe or ECT or the European Union member states which are being affected. As we know, there are many US investors investing in European member states. So would world be better off, even though it's a European problem? Is my question.
Yeah. Nikos, why don't you take the first stab at this, although I think I have a strong sense of what you might say, and then there'll be a question behind you then, Jose Antonio.
I honestly, truly believe that the ECT text would have been better. Now that the ECT text, I think, is effectively off the table, yes, you might rely on the 20-year sunset clause, but I'm not so sure if, or let's put it differently, there are a lot of good lawyers in the EU, in the European Commission, that will find ways to try to kill the 20-year sunset clause, so I wouldn't bet my money on that. And that could lead to the effect that, there will be no protection in any event, at least for intra-EU. And while I really understand what Eureka was saying, trying to contain it to the intra-EU scene, I think it's very hard to exclude the possibility that it might spill over also in extra-EU disputes, as was the case with the Comstroy case, because the Comstroy case was Ukrainian company against Moldova. There was nothing about EU member state or EU law. The only fact was that Paris was a seat of arbitration, right? So I would be very careful. So to put it shortly, in a nutshell, the less treaty protection you have, so going down from the ECT modernization text, which is not available anymore, removing the old ECT text completely, you're left with nothing but EU law, yes, the Charter, and also we shouldn't forget, we have also the European Convention of Human Rights. So if you want to litigate for 20 years to end up in Strasbourg, you know, you can get maybe protection there. So, you know, it's possible, but it's just all becoming so complicated unnecessarily, you know. So it's a huge waste what the EU and the member states are doing just for the sake, and I'm concluding now, for promoting the superiority and the primacy of EU law. And I think that's really a pity, really.
Can I just add very briefly? I mean, if you look at the cases against Romania, Croatia, you know, you have foreign investors, CEOs being thrown into prison and outright expropriation. And there's no recourse for that within the European Union other than these treaties. So what incentive will these countries, many of which were probably admitted to the EU far too early, you know, they don't have developed legal systems. What incentive will they have not to expropriate, not to take adverse action against the investors' executives? None. I think these decisions have set back the rule of law in many EU states by decades. And I think the consequences of the decision are going to be, I'm not optimistic. I think the consequences will be pretty grave and pretty serious.
Yeah. Thank you very much for the very fruitful event. So I have two actually concern about like ECT. The first one, like, because the EU already initiated like the investment cost system. So is it effect to the ECT? Have any effect to the ECT? Or if not, so how about the futures? Whether the ECT have to establish the like appellate body or the tribunal? And the second concern is like, because I come from the Vietnam, so we have a like EVFTA in what you mentioned about the ECT, not ECT, but the like the investment cost system. So I'm very concerned whether is there any movement of the EU in terms of appointing the tribunal for that causes.
Yeah,
Thank you.
So far, no. The investment court is still very much in its primordial state. It has not really evolved much beyond a thought and a concept. It's a well-developed concept as far as I understand it, but it is not moved, and it is the announced policy of the European Union, so that's significant, because we all know when they announce policy, they like to see it carried out. But it hasn't advanced to a point where EU Vietnamese cases are going to be adjudicated by a standing investment court. So that's interesting. Now, query if they'll ever be adjudicated EU Canada. I have my doubts, but that's an answer to that. Chris, bringing you back into the conversation here on the rule of law question. When you're counseling clients on the availability of the EU as a place to enforce judgments, irrespective of the ECT related issues, are you seeing a sea change there? We've heard dire predictions about the EU's fidelity to law. What's your view on other matters that are seeking other folks that are seeking enforcement and needed?
Certainly, and I should put a big caveat on here. I'm the non-lawyer on this panel, so my counsel is usually on, the collaboration with enforcement counsel. The asset, what I've seen in commercial arbitration settings and other things, is definitely a sea change in what Nikos has raised, which is, given Comstroy, what's the next shoe to fall? And it raises a lot of questions about, do we want to be a test case in something that may transpire here? given the series of rulings, given what's happened post ACMEA, post Comstroy, like what's the next bit? But when you're dealing with purely commercial assets, there's not an ECT patina. There's not a sovereign element. It is one of the common places we love to play. I raised why everyone wants to run to the Netherlands. It's definitely there, but at least in the last year plus, there's definitely been a shift to a gun shyness about where people need to go. And again, it has us nibbling around the edges of like, what jurisdictional nexus can we find in the US, Australia, Canada, places where the rule has not been set, and maybe, just maybe, there's some Eastern European kind of toe print that we can exploit for at least disclosure, let alone anything else.
So let me go back to, thanks, that's very helpful. Let me go back to this point about protection of investment provides investment or promotes investment. Isn't there an argument, and this is now me adopting a character, but isn't there an argument, and I think it's certainly a reasonable argument, that the EU and its market is so sophisticated, so robust, so lucrative, that you don't need this in order to entice investment. This is Brazil's argument for its own economy in many respects, and some have suggested that it's going to very shortly be the announced policy of the United States. You don't need to protect investment with an international treaty to encourage investors to come to a sophisticated, regulatorily powerful, lucrative market. Eureka.
Well, if I may react on that, actually, I think on the one hand, you're on the right track, actually, at least of the reasoning of the European Court of Justice. But I think there are 2 points to make. On the one hand, what I said before, the EU still has treaties with third countries, and also EU member states still have treaties, at least they're governed now under the grandfather regulation, but the EU member states also have these treaties in place with third countries. The story is very different for internal EU investors. And that is, again, kind of the distinction that I try to make, because what are EU investors? EU investors are basically your domestic investors. The whole Treaty of Rome and the whole EU is founded on the idea that if you are a French investor, you are treated as if you are a Dutch investor if you are investing in the Netherlands. So you have exactly the same rights as every other domestic investor in the Netherlands. And that is the whole idea of this EU ecosystem, the EU bubble. Within the EU, all EU investors, EU citizens are treated the same. And it's a dogmatic reasoning. It indeed also kind of assumes that the rule of law is equally good and equally applied throughout the EU, but the EU law itself, and it's what I said, a dogmatic reasoning, should provide for all its citizens the same level of protection. And it has nothing to do basically with the rights of investors outside of the EU, but really from an EU perspective, you don't want any discrimination, different treaties, or different treatment for.
So in your view, if in order for that dogma, as you put it, to hold, we wouldn't be seeing any resistance by the EU for non-intra-EU related investor state arbitrations, and yet we are, because they are potentially sitting on questions that touch upon EU law. So how do we square that dogma with the reality of the EU's position for foreign non-EU investors suing EU states?
Well, but that is the question that the European Court of Justice tried to solve also in its opinion 117 on CETA. And as long, and now I come back again to the autonomy of EU law, as long as the EU institutions and the EU member states ensure that whatever international obligation they adopt is compatible with EU law, as CETA, for example, already kind of goes beyond what traditional BITs have in terms of applying some sort of mechanism, making a big divide basically between what is in the realm of EU law and what is in the realm of international law. And they basically say that these international treaties with third country investors are considered international law, and the EU can be bound by it, as long as those tribunals respect the underlying interpretation that EU courts give to EU law. So there is a mechanism foreseen, at least in CETA, that at least gives some sort of feedback loop to the European Court of Justice to give an interpretation on EU law if that is in dispute. So given that's kind of, that should kind of, at least for the future, provide some solace.
Yeah, I mean, I guess by dogma you mean aspirational, and it is aspirational because it's not, it's fictional right now. I mean, the notion that the rule of law is equal throughout the EU just isn't the case. And I'm reluctant to go into my cases, but we are representing a Hungarian investor against the Republic of Croatia. Our client invested about $2 billion to basically take management control of the main energy company. Everything was great until a new government came in and decided they didn't like that. And they found a witness, a single witness, who had received 5 million euros from a Cypriot company controlled by Russians. And he said, well, actually, this was a bribe from Mol to the former prime minister. And that's how Mol got this deal. There were two separate arbitrations before really, really good arbitrators who said there's this one witness, he's totally lacking in credibility, his story is self-contradictory, there's no documentary evidence. We've had forensic accountants examine this. The money didn't come from Mol. The money never reached the prime minister. In fact, the guy who gave the testimony was facing 5 other criminal charges, which he was then excused from, and he never gave back the money. He has the money in his Swiss bank account. So our tribunal said, this is a joke and there's no evidence of bribery. The Croatian court went ahead and convicted our CEO in absentia. There is still a red notice out for him. And we cannot enforce the award anywhere in the EU. We'll see if we can enforce it elsewhere. But, again, I think the setback to the rule of law and the lack of looking at these situations with any sort of realistic eye, is a disaster.
Anyone else from the audience? Yeah, Mike.
Thank you. David Ingle from Allen & Overy. It was explained that the rationale behind Comstroy and Achmea was protecting the autonomy of EU law, essentially the idea that ECT tribunals or any tribunal under an investment treaty cannot refer a question to the CJEU, a question of EU law. On what basis then is commercial arbitration permitted? Because of course, commercial arbitration tribunals may have to interpret EU law, but they also cannot make a reference to the CJEU. So that's something I've never quite understood. How could one not be permitted and yet the other one is?
I mean, that seems to me like the logical extension of Achmea and Comstroy, right? And the Greek Supreme Court recently held that Achmea and Comstroy apply to commercial agreements, commercial concession agreements with the state. So, I mean, the reality is arbitral tribunals decide issues of law from other jurisdictions all the time. And they sometimes decide that international law trumps domestic law. So this jealousy about protecting EU law is inconsistent with arbitration as it's existed, for hundreds of years.
Well, let's not throw too many stones, seeing as the United States Supreme Court just ruled that arbitral tribunal is not a tribunal for purposes of 1782. But moving on,
Yeah.
Do you have a?
Yeah, I mean, this is also
Throw stones at everyone.
a good question. And if you look to the Achmea decision, the Court of Justice tried to make a clear distinction between what applies to investor-state arbitration, treaty-based arbitration, and what applies to commercial arbitration. And the court reasoned that basically, because this was a treaty-based arbitration, it may relate indeed to the interpretation and application of EU law. these tribunals established under the treaties are not part of the EU system and hence cannot have any oversight from the European Court of Justice. So therefore, it might seem a bit as an artificial reason, but I've always understood it basically as a warning to the EU member states themselves that whatever they do, they need to oblige and adhere and are subject to the oversight of the European Court of Justice in whatever they do. And I think that is kind of the bigger message from Achmea and maybe from Comstor Holdings. So indeed, I don't know exactly the details from the Greek the Greek decision, but as I understood it, and also how when I worked for the Netherlands, we understood it was a clear warning for us not to subject any matter that may involve the interpretation of EU law from the oversight. But commercial arbitration, commercial parties, these are actually not affected, and that's also what in Achmea, until now at least, has been very clearly stated, that commercial arbitration is still something that can be pursued also in an EU context.
But if I may just to add, because I think it's that's all true, but I think the artificial point that the court is trying to make was the issue of consent, that there is a different type of consent with regard to states when they give consent through the BITs and to offer to arbitrate and to perfect the consent, and the consent that commercial parties give to each other in terms of arbitration. So I think that is something that cannot be properly explained in a logical way, I think, because I think consent is consent. But I think the main reason, I believe, is that actually the European Court of Justice wanted to preserve the commercial arbitration industry and not kill that as well, at least not with one stone. I think that is an important point, because we should, of course, realize that commercial arbitration takes place 100,000 times more often than those few ISDS cases. And if you look at the mass, and also in terms of the work of law firms, 90% is commercial arbitration and 10% is ISDS cases. So I think there is one element there that we need, I think, to consider. And finally, I think another point is that in commercial arbitration, at the end of the day, there will always be a domestic court of a member state that will supervise, so to speak, the award, either through the process or when it comes to setting aside or enforcement recognition, and be able to ask preliminary questions to the CGU, which is not necessarily the case, at least not with ICSID cases. Now, the problem was that the European Court never made a distinction between ICSID and non-ICSID cases in all its, case law. So I think there are a couple of more elements to take into account. But personally, I was never convinced, and that's why I'm afraid, it might sound all apocalyptic, but that's why I'm afraid that this distinction, which is still there between commercial arbitration and ISDS, might not hold forever. And we must be prepared for that at some point, and the Greek court decision might be a first indication that, Achmea can spill over, perhaps, to commercial arbitration. So we must be careful on that point.
Well, on that uplifting note, Nikos, which I appreciate. Unfortunately, you won't be able to share in the refreshments that we've offered, and your consent to being here, being those, and I'm sure there's a spillover metaphor here, but I'm failing. But let me thank our panelists and thank our gracious organizers, and apologies for some of the technical difficulties, but thank you all for being here, and please join us outside.
Thank you. It was a pleasure.